Well, welcome everyone. Thank you for being with us today. My name is Bob Harris, and with me today is Bonnie Roy. We are from the California State Auditor's Office in Sacramento, California. We're excited to be with you all to discuss the results of an audit we conducted related to California's involuntary mental health treatment laws. Before we get into the audit itself specifically, I wanted to give everybody a little bit of background about who we are and what we do that might be helpful as we go through today's presentation. As our name of our office suggests, we are auditors. Our office conducts a variety of different audits throughout the state of California of local government agencies, state government agencies, and programs. And the large majority of the audits that we conduct are what we call performance audits. And those are evaluations of how well government operations or services or programs are performing. So we do a detailed review of the particular subject or program or agency that we've been asked to take a look at to figure out whether it's working as efficiently and effectively as it can. And if we feel like there's areas for improvement, we make recommendations for how we think government can function even better and serve the people of California even more optimally. Now, to do that work, we're actually granted pretty unique access to records and documents and data that the general public doesn't have access to. And that's necessary for us to conduct our work. And it also allows us a very unique opportunity to review the operations of government in a way that no one else really can. So in this particular audit example, we're discussing medical records or criminal justice records or court records that ordinarily people in the public wouldn't be able to review or have access to, but it allows us to do the audit work we need to do to answer the questions we've been given by our state legislature. So that evidence that we review, that documentation we're able to access, also allows us to meet our very high evidentiary standards. Under our government auditing standards, we are required to be able to support and back up every conclusion we make in our audit reports. So having access to that information both allows us a unique lens into the operation of government, but also allows us to be able to support and document the backup for all of the conclusions we reach during our reviews. So with that little bit of background about who we are and how we do the work we do out of the way, I'm going to hand it off to Bonnie, and she's going to step us through the history of involuntary treatment law in California, where we started from, and how we got to the audit request that we were asked to fulfill a couple of years ago. So Bonnie, why don't you take us from here?
Thanks, Bob. So what we're talking about today is the crisis care component of mental health care in California. Millions of Californians experience mental illness, including about 2 million people who experience serious mental illnesses that substantially interfere with major life activities. The state's mental health care is generally provided in community settings and on a voluntary basis. And it's the state's 58 counties that are responsible for providing mental health care. Within this generally voluntary, community-based mental health landscape, the Lanterman-Petra-Short Act, or LPS Act, as I'll call it today, is the state law that outlines the circumstances under which involuntary mental health evaluation and treatment can occur. The legislature added this act to state law in 1967, and it was part of a broad effort to deinstitutionalize mental health care in California. The aim of the act was to end the inappropriate, indefinite, involuntary commitment of people with mental illness. At that time, in 1967, the legislature intended to provide for prompt evaluation and treatment, to protect the public, and to safeguard personal rights through consistent standards. Fast forward about 50 years later, in 2019, members of the legislature raised concerns that our 58 counties might not be implementing the act in consistent ways. Because of their concerns, which Bob is going to elaborate on in a moment here, the legislature directed our office to conduct an audit of how Los Angeles County and then 2 other counties were implementing the LPS Act. So we selected San Francisco County and Shasta County, which is in the far north of our state, to include in our review. And this allowed us to look at urban and rural communities and to look at small and large counties' mental health systems in different geographic regions of our state. Today, we're talking about two of the major findings that came out of that review of the 3 counties. One is that these 3 pretty different counties were actually implementing the act in fairly consistent ways. But the other is that people who received crisis care under the LPS Act generally did not receive adequate ongoing care afterwards in the broader components of their county's mental health systems. So I'm going to pass it back to Bob now, and he's going to start us off with a description of that first finding on the implementation of the Act.
Great. So as Bonnie just outlined, the LPS Act defines the way California approaches involuntary mental health treatment, and it's really designed or intended to be a crisis care component of a broader mental health care system. So it was never intended to be long-term care or long-term treatment for individuals. They're really supposed to be there for dealing with individuals who are in a moment of crisis due to a mental illness. And so I want to do really quickly before we get into the audit finding is outline in a little bit more detail the 3 different stages of involuntary care or treatment that someone can be placed into in California and the criteria and the law around when someone can be placed on an involuntary hold. So under the LPS Act, there are, like I said, 3 different stages or phases of involuntary holds. The first and the most common is what we called in our audit report a short-term hold. Now that hold, the involuntary hold duration, can only last for up to 72 hours in time. It can actually end sooner as well, but it's limited to a duration of up to 72 hours in length. That's why we call it a short-term hold. And it's the one that most people who are involuntarily treated in California have the most frequent interaction with, according to the data that we reviewed. In order to be placed on an involuntary hold of 72 hours in length, a person has to first be assessed by a designated professional named in the law, typically somebody working in a treatment facility, and that individual has to reach the conclusion that the person is either one of 3 things due to their mental illness. Either they're a danger to themselves, they're a danger to others, or they're what state law in California calls gravely disabled. And it explains that gravely disabled means the person's unable to provide for their own food, clothing, or shelter. So the designated professional has to reach the conclusion that due to the mental illness, the person's a danger to themselves, a danger to others, or can't provide for their own basic needs. And that hold duration is, like I said, capped at 72-hour period. But there's a second stage of holds as well, and it's what we termed extended holds. Now, extended holds in California can last for varying lengths of time depending on the circumstances involved in the individual case. The most commonly used extended holds in California are those that are capped at an additional 14-day period. So past the 3-day period, the most common extended holds last for up to an additional 14 days. Now, at this stage, the criteria for being held are the same: danger to self, danger to others, or gravely disabled. But the level of protection built in around that individual's rights increases. They're able to appeal and receive guidance about whether their continued involuntary hold and treatment is appropriate, and can seek a secondary review of the appropriateness of that hold. And this is state law's balancing or attempt to balance the imposition on the individual and the involuntary nature of the treatment and the duration that can last for with the individual's rights as a person to sort of self-determine. So that will be a feature also of the 3rd stage, an escalation in the protections around individual rights. The 3rd stage under the LPS Act is conservatorship. Now, California has a variety of different conservatorship types. We focused in this audit on those under the LPS Act. Conservatorships under the LPS Act have to go before a court before they can be granted. So in this case, we see, again, the escalation of protections around the individual's right balanced with the duration and time that a conservatorship can last. Because in California, under the LPS Act, conservatorships can last for up to a whole year in time, during which the person might be housed in a locked facility or some other very restrictive environment and treated. So because of the length of time and the conditions under which someone might be conserved, state law places the burden of proof on the person seeking the conservatorship to prove to the court that the conservatorship is warranted. The other thing that distinguishes conservatorships from the other two hold types in California are the criteria for conserving somebody. In the other two hold types, it was 3 different criteria: danger to self, danger to others, or gravely disabled. But for conservatorships, state law restricts them only to those who have been determined to be gravely disabled, unable to provide for their food, clothing, or shelter due to their mental illness. So we also see a narrowing of the conditions under which somebody can be conserved. So as Bonnie mentioned at the outset, there was some concern that led to this audit being asked for. And the concern centered around a couple of different areas related to those 3 criteria: danger to self, danger to others, gravely disabled. And in a nutshell, concern number 1 was that the counties might be inconsistent in their application of those criteria. And that would be bad or concerning because it would mean that the level of treatment or assistance that somebody might receive in California for their very serious mental illness might vary based strictly on where they happen to be located in the state. In other words, the counties who are responsible for implementing the LPS Act might be taking very widely divergent understandings or interpretations of what it meant to be a danger to others or what it meant to be gravely disabled. The secondary concern was related to the first, but it was a slightly different version. And that's that maybe there's not inconsistency in the way counties are applying the law and the criteria, but perhaps they are too narrow in how they are applying it. Perhaps they are setting the bar in a burdensome way, very, very high, too high in the opinion of some people, to be providing effective treatment to individuals in need. So we had these 2 kind of very key questions about how well is the LPS Act working in the counties that we reviewed. So to take a look at those questions and try and answer them, we took a look at a variety of different case types. So across the 3 counties, we looked at 60 different decisions to place individuals on short-term or extended holds. And we took a look at those 20 in each county because they were decisions by designated professionals that individuals did in fact meet the criteria for being held and treated. We also wanted to do though is take a look at 60 different decisions of the opposite, 60 different cases in which individuals came to the attention of designated professionals, but the decision was made not to place the person on a hold because they didn't believe they met the criteria for being involuntarily held and treated. So in those first 60 and 60 groupings, we had kind of the 2 halves or the 2 different ways that decision could be made when an individual comes to the attention of a professional. Then in the last grouping, we took a look at 60 different conservatorship cases that came before the courts, where the courts determined that the individual was in fact gravely disabled and placed them on conservatorship. And so with these different buckets of case types, we were able to review the medical records, the criminal justice records, the court records related to all of them, and assess these 2 core questions. Is there inconsistency from one county to another? And is the burden too narrow or too high for individuals who may actually need treatment and be in a moment of crisis? And are they able to get that treatment in that moment of crisis? Or are counties and designated professionals restricting access to care or restricting the care that they provide to folks because of too narrow of an application? Now, on the conclusionary side, what we found was that there was no evidentiary reason in the cases we reviewed to be concerned about either of those 2 questions. What we found was that counties, the 3 that we reviewed, were taking fairly similar approaches to similar circumstances, both in the decision to place someone in an involuntary hold and also the decision not to. Now, the counties varied in the level of guidance that they had developed around these criteria, but that varying level of guidance didn't really affect the actual decisions on the ground. Counties were being very consistent with one another in terms of the different types of circumstances when they were similar from one county to the next were being treated the same way. Also, with respect to whether the decisions were being made in an overly narrow fashion, we found that they were not. In fact, what we found was that they were appropriately broad in their consideration. And what we mean by that is they were balancing individual rights with the idea that someone might meet the criteria in the law. For example, to be considered a danger to themselves, Counties were not strictly requiring someone to have expressed suicidal ideation. They were also considering other circumstances stemming from a mental illness that might cause someone to be a danger to themselves, such as delusions they may be experiencing that would cause them to self-harm. Also, as an example, with respect to the gravely disabled criteria, courts were not expecting people to be homeless in order to demonstrate that they were unable to provide for their own shelter. They considered a broader array of circumstances that might reasonably lead someone to be unable to provide for their own shelter. So with respect to the two key concerns about the LPS Act and its implementation, our audit actually concluded that there wasn't a basis for concluding that the act was being applied very inconsistently across the state, or that it was being applied in an overly restrictive way. Rather, we found the act grants counties and designated professionals the ability to do what they need to do in order to provide treatment to people who are in a moment of crisis. Our main concern in the audit, and what Bonnie's going to step us through next, is actually what happened to those individuals after they exited the crisis care system. We found significant evidence to show that people weren't receiving adequate treatment through the county's other components of its mental health care system. And I'll let Bonnie explain our findings in that area.
So like I said earlier, involuntary treatment is just a small component of mental health care, which is generally community-based and voluntary. And as Bob described, state law allows involuntary holds when someone poses a risk to themselves or others, but it requires holds to end when that risk subsides. As you can imagine, there's a meaningful difference between being stable enough to leave a hold versus being capable of maintaining self-care and mental health. So we expected that people who had received crisis care would then receive less restrictive but still intensive levels of care in their communities. Unfortunately, we saw troubling indications that this wasn't happening. First, we saw that people were cycling through multiple involuntary holds. We looked at data on short-term holds that another state agency, the California Department of Justice, maintains for public safety purposes. As you can see from the pie charts on your screen, many people in each of the 3 counties we reviewed were placed on involuntary holds multiple times during their lifetime, indicating they repeatedly experienced mental health crises and crisis care. For Los Angeles, for example, you can see that 43% of the people who'd experienced involuntary treatment under the LPS Act have been placed on multiple holds in their lifetime. And of the 166,000 people represented in the pie chart for Los Angeles, nearly 10,000 had been placed on more than 10 holds in their lifetime. The numbers and the percentages were lower in San Francisco and Shasta, but as you can see, a significant percentage of people in those counties also had multiple holds over their lifetime. We saw a similar pattern when we looked at conservatorships. Roughly 1 in 4 of the people from our review successfully recovered during conservatorship and returned to their communities, but then later were conserved again. So one of the questions we asked was, why was this cycling happening? When we looked at holds, we found that people were not transitioning from a hold to a less restrictive, still intensive form of care as we had expected they would. We identified people who'd been placed on 5 or more holds from 2015 through 2017. So people who had needed crisis care 5 or more times during that 3-year period. And we reviewed how many of those people were enrolled in 2018 in either of 2 programs that are the most comprehensive and intensive methods available to all counties for providing community-based care to people with serious mental illness. The image you see on your screen now summarizes the situation that we found in Los Angeles and San Francisco. I'll just note that the values in the figure are approximated to protect the confidentiality of the people whose files we reviewed. For the same reason, we didn't present data related to Shasta County, where the population was much smaller. But as you can see in the figure, very few of the people we reviewed were getting intensive care after mental health crises. A key reason for that was that counties were largely unable to access the kind of information that we were able to review about people who had had a hold or multiple holds. So counties can coordinate with treatment facilities to find out who may be leaving a current hold, but they couldn't get at the kind of data we saw that showed holds over a lifetime or included individuals' holds in multiple counties. All of that information could help them identify people with a high need for care. So that lack of information caused people to cycle through multiple holds without getting stabilizing care afterwards. That's for the holds. When we looked at individuals who were cycling through conservatorship, medication was a critical factor. So we saw that after recovering during conservatorship and returning to their communities, many people stopped taking medications and they experienced severe symptoms again, as well as effects like homelessness and incarceration that further degraded their quality of life. Their illnesses made it difficult for them to voluntarily take medication that was critical to their continued health. All but one of the 60 people whose conservatorships we reviewed had a history of not taking medication or limited understanding that they had a mental illness and needed medication. One of the intensive community-based mental health programs that I mentioned a few minutes ago is capable of addressing this problem. California's Assisted Outpatient Treatment Program, which is commonly called AOT, this is a program that gives counties an option to provide involuntary treatment without placing individuals on a hold or a conservatorship. Evidence shows that AOT successfully improves outcomes for people who lack insight into their illness, so aren't aware that they're ill or need medication to treat an illness. AOT is a court-ordered form of treatment, so similar to conservatorship, it involves a high degree of protection for personal rights. But AOT is less restrictive than a conservatorship, which, as Bob described, might take place often in a locked facility or involve treatment that includes physical restraint or seclusion. So these characteristics make AOT a promising step-down program from conservatorship to a less restrictive form of care. But we found that state law made it difficult, if not impossible, for counties to use AOT in that way. There were a few reasons why. So first, state law required a person's mental health to be substantially deteriorating for them to access AOT. But state law required for leaving a conservatorship someone's mental health to be recovering to the extent that they could provide for their basic needs and access mental health services voluntarily. So those criteria were incompatible. Second, the law did not expressly authorize court-ordered AOT treatment plans to include medication requirements, even though we saw that medication was really critical to continued health. Third, the law allowed all counties in California to provide AOT, but it didn't require them to do so. And at the time we published our review, which was in July 2020, only 19 of our 58 counties were offering AOT. So we identified these problems, and it was also our job to recommend solutions that the counties and policymakers could implement to solve those problems. Bob is now going to talk about some of the recommendations that we made.
Yes. So as Bonnie mentioned, we made a variety of different recommendations. I'm going to focus mostly on the recommendations we made to change state law in California. So first, related to the issue of access to information about holds, as Bonnie mentioned, we were able to access information from the California Department of Justice about the frequency with which individuals were placed on involuntary holds. But the counties who were responsible for treating those individuals and providing them mental health services were not able to access that same data. So we recommended that state law be amended to facilitate the transfer of information from the Department of Justice, which has a legitimate public safety interest in that some of that data, to the county governments that are responsible for providing the mental health services. And we saw that as an effective way to get the counties the data that they would need to better effectively serve those who need their help. Now, state law up to this point hasn't changed in this regard. Some members of the legislature have introduced legislation to make the changes we recommended, but those bills have not yet progressed all the way to full-blown changes in the law. Secondly, related to AOT and the changes that we recommended there. First, we did recommend that California require all counties to offer AOT as a treatment option. And while the legislature hasn't fully adopted that recommendation, it adopted a version of it. Essentially, in California, before our audit report and before our recommendation, California counties could silently decide not to adopt AOT. They didn't have to provide a public accounting of why it was not part of their mental health service suite. What the legislature did in response to our recommendation was slightly different than what we said. We said require all of them to do it. The legislature amended the law to require at least a public accounting of why counties would or would not be adopting AOT. And that public pressure that created really caused a sea change in how many counties were offering AOT. Since the recommendation was issued and since the change to state law, where counties now have to publicly declare whether they're going to opt to offer AOT or not, we've seen 10 additional counties in California adopt AOT, and that has been considered to be a very large shift in the space of AOT because the adoption rate heretofore had been very slow or static. So that's positive progress on one of our recommendations related to AOT. The second recommendation related to AOT that we made was that it should be available as a step-down option from conservatorships. Like Bonnie described, the criteria for leaving a conservatorship and being eligible for AOT were incompatible before our office recommended that those two programs be bridged. In other words, people leaving a conservatorship should be eligible for AOT, where they can receive intensive but community-based care. And the legislature has fully adopted that recommendation. So now under state law in California, individuals who are leaving conservatorship can transition over to AOT services to help them remain stable, but set in a community setting. Finally, on the issue of a medication being explicitly allowed to be in court-ordered AOT treatment plans, we haven't seen the legislature adopt that recommendation yet, but we're continuing to track the progress that might be made in that area moving forward. With that, I'd like to thank you all for your time today. It's been a pleasure to share the results of our audit with you. If you have any questions about the audit, or if you want to read that or any of our other audit reports, you can find them all on our website, which is auditor.ca.gov. Again, that's auditor.ca.gov. Thank you all for your time, and we wish you all the best.